We're all getting a reminder today of why Brussels is so green, which is, I guess, healthy for the plants, not so healthy for everybody else. Hopefully the noise behind us will also die down. I want to thank everybody for coming. This is not the only or even the first discussion of the AI Act today. It's obviously on a lot of people's minds. We're going to try and add some new and different perspectives to the discussion, however. We have here a wide variety of expertise and viewpoints for the discussion. We're going to kick off with Professor Georg Borges from the University of Saarland, who's going to give us an overview of the roles and responsibilities under the AI Act. Then we're going to move on to Dr. Elżbieta Krosova, I hope I pronounced that correctly, from the Czech Academy of Sciences. Then we're going to move on to BEUC, Dr. Frederico Oliveira da Silva, who is going to be presenting a consumer-oriented perspective on the AI Act and how it could or should be reinforced, and return to the real world, or at least the world of the companies that are actually designing and developing these systems with Cornelia Kutterer, Senior Director of Government Affairs at Microsoft here in Brussels. I'm Jay Modrell, Head of Office for Norton Rose Fulbright, very interested in the AI Act, but more of an antitrust lawyer, so I will do my best to bring the discussion back to antitrust as often as I can in the next hour or so. And we will reserve time at the end of the discussion for questions and comments from the floor, of which I hope there will be many. Georg, do you want to kick off?
Yep, I will do. Standing here. Good afternoon, everybody. I have a control of the slides, which I was preparing earlier. I hope someone can see them now. Of course not. No, the second one. We are talking about the AI Act. Let me briefly give you an overview of that animal which you already know. I just want to briefly mention that we have different. How is it working? Doesn't. That's technology. There are different concepts. For some part, it prohibits the use of certain technologies. And secondly, and mainly, it offers a risk management concept with regard to so-called high-risk AI systems. And last but not least, it's about transparency duties regarding also a number of different AI systems. So as a very first conclusion, it's obvious that despite its very general name, the AI Act, the proposed act is not at all a comprehensive legal framework for AI. It doesn't cover liability, for instance. It is not more and less than product safety law for AI. Okay, it never works. What is it regulating? Some people refer to AI systems as socio-technical systems. Why is that so? Just because they are defined, AI systems, as systems which interact with humans. And also Article 52 refers to the interaction of AI systems with a natural person. So as a second easy conclusion, we can conclude that AI systems are systems which are intended to interact with humans, which means they generate outputs, they show a kind of behavior. And that's important in my view. That behavior, that output is depending on the operating environment of such system. I was supposed to talk about roles and responsibilities regarding AI systems, and the AI Act, interestingly, divides only two main roles. The one of the provider, and that is the manufacturer of the system, who puts it into market, who develops it, He is the HRC of mainly all the duties regarding risk management, a large list of exhaustive duties. On the other hand, we have the user, which is only professional user. Consumers are not addressed by the Act at all. And that user shall use the system in accordance with the instructions for use, made up by the provider. So, interestingly, the user is put in a somewhat consumer-like role. I think there are some shortcomings of the concept, even though overall it's a very nice piece of legislation which is able to transform the product safety rules into the next century. However, there are some shortcomings. I would like to mention two of them. First of all, there's an excessive binding of the user. He is bound completely to instructions for use. He cannot decide on how to use the system on his own. And that's why the potential of AI cannot be fully exploited, just because there's excessive binding. Also, the user is not addressed in the risk management concept, so his potential to minimize risk is not used at all. Also, and secondly, the role concept does not reflect the multi-stage process of providing such an AI system, where we have a huge chain of providers on different steps. And the responsibility is only on the last provider, not taking into account all the other players in the role. And that is the problem, since any adaptation of such system will lead to the fact that the last one who is doing an adaptation will be considered provider having all the duties. And that's why it is highly risky to do this adaptation, and that will not be easily possible for SME. So the potential of smaller entities cannot be harnessed by this concept. I think that's another shortcoming. Thank you very much.
Thank you, Georg. Asberta, do you want to take us on to the next part of this discussion?
I'd love to. May I stay sitting?
Yes, of course.
Perfect. Thank you very much for the presentation. On my side, what I would like to tell you about the AI Act is I will tell you about the Czech position, since the Czech presidency is coming up as of the beginning of July. So let me enlighten you a little bit what the Czech Republic has been doing in the area of AI regulation. We actually started already in 2017 when Czech Republic proposed to Ancitral and Unidroa to start working on regulation of artificial intelligence. We've had several studies. One of them was for the Government Office of the Czech Republic, where we identified that actually the main problem with artificial intelligence are the questions of liability and the problem with transparency of AI systems that are then causing the problems in liability. We could see that some companies were calling for more transparent regulation and for legal certainty. So we were kind of pushing legislation related, especially international legislation related to AI. However, when the AI Act was published, the discussion in the Czech Republic turned into the direction that actually maybe we should refrain from initial over-regulation. In my perspective, AI Act is a very interesting piece of legislation that is trying to solve several problems, especially when it comes to protection of fundamental human rights, and it also contributes to solving the questions of liability, although it's not per se legislation focused primarily on liability. Now, when it comes to AI Act, and now I am quoting from the Czech non-paper on AI regulation, What the Czech Republic was promoting was prohibition of certain techniques that actually were reflected in the AI Act, such as prohibition of social scoring or let's say prohibition of manipulation techniques, or let's say reserved position to those techniques. On the other hand, as was shown already, the AI Act can really hinder innovation because it proposes a number of obligations that might not be possible to fulfill by certain companies, and it can prevent them from entering the market. So we are going to try to find a certain balance between the obligations and also the means of innovation. One of the principles that I personally value is promotion of principle of autonomy that, for instance, was reflected or in not in AI Act, but in other proposals of acts that are actually promoting the enhanced users' control over personalization, explanation, and switching off or having default settings for personalization.
Thank you, Elżbieta. I think both Georg and Elżbieta have presented the AI Act from a, very broadly speaking, the perspective that maybe it goes too far, maybe it is going to inhibit innovation. I'd like to come back to that because I'm not entirely sure I'm persuaded by that argument. But I think that Federico is likely to come at this from exactly the opposite perspective, that perhaps the AI Act doesn't go far enough. So hopefully they will not take this debate outside, so to speak, but we can hear the debate actually live and in person.
Of course, thank you very much, and it's a pleasure to be here. Thank you for the invitation. No, exactly. Indeed, our perspective is that the AI Act does not go as far as it should. But coming first to the starting point, we very much support the Commission's intention to regulate AI horizontally. We think that was very important, that the Commission came up with a proposal after so many discussions on this topic. So we very, very much support the instrument that we have in front of us. That being said, there is indeed the need to go further on several points. Part of the problem of the AI Act is a conceptual problem in our view, and it's based on the fact that the AI Act heavily relies on what in Brussels we call the new legislative framework, or the NLF. So the NLF is the regulatory approach that the Commission has used over the past decades to regulate product safety. But the reality is, when you think on products, as you were thinking in the early 2000s, that is a very different product of what AI currently is. So applying this regulatory approach to AI has some limitations. For example, it was already mentioned in the previous panel that individuals are completely excluded from the scope. It was mentioned as well by the first co-panelists that the users under the AI Act are the business users. So we don't have individuals, consumers, citizens adequately represented under the AI Act. A second point that is also a reflection of the new legislative framework is the fact that the majority of the obligations are aimed at the developers of the AI system. And we know that when we're talking about AI, of course, the developing stage is very, very important, but we also need to take into account of the context in which the AI system is put into use. So that means that on top of the developers having very strict obligations, we should think as well on establishing certain obligations for the business users, for the deployers. And finally, in terms of limitation on this use of the NLF approach, is the standardization process. So NLF legislation, so the Toy Safety Directive and all the product safety legislation, relies a lot on standardization, and the AI Act has a consequence as well. And we understand that, provided that civil society is well represented in the forums where the important discussions are taking place. But the problem is that the AI Act goes a step further. Here they go a step further, and they shouldn't have, in the sense that standards were created to apply technical requirements. And what the AI Act is allowing the standardization process to do is to apply legal principles, legal values. And that is something that should not be dealt with under by the private sector in a private forum, but by the co-legislators in a legislative process. So that is something that really needs to change over the course of the negotiation process. And just very, very briefly, and then I can dive deeper later in the discussion, a few areas that need to be addressed to improve, sort of, to counter these existing risks. The first one is that all AI systems should be subject to certain principles. So at the moment, as most of you know, the AI Act follows a risk-based approach, which is heavily focused on high-risk AI systems. And our view at BILC is that not only high-risk AI systems, but all AI systems should have some sort of safety net, which currently does not exist under the AI Act, except for the very light approach regarding Article 52. So here our solution would be to introduce a new provision, establishing a set of principles like accountability, transparency, robustness, that will cover all AI systems, and not only high risk. It's also important to take into account, we talked previously on Article 5 and on the list of prohibited practices, and how important it is that the AI Act, and particularly Article 5, is future-proof. By having this horizontal provision that would ensure that dangerous practice that perhaps should be prohibited would at least be regulated to a certain extent. Another point, and then I'll finish here before moving on, is that individual rights need to be introduced in the AI. So we spoke about this. You cannot unroll such a powerful and complex technology without granting the users, ourselves, with the tools, the necessary tools to protect ourselves if some harm comes about. And this, for example, means introduction of a right to an explanation, meaning that if an AI system takes an important decision about our own lives, that decision should be accompanied by the information about the fact that an AI system was used, the role that the AI system took in that decision, the logic regarding that AI system as well. And a second set of rights that should be introduced, which is very, very important for BILC as the consumer organization, is a right to seek redress. So under the Commission proposal, we don't have at all the possibility for consumers to seek redress. This has not been envisaged. The European Parliament is already moving towards that direction, which we very much support, but we should at least include a right to complain, so citizens, consumers should have the possibility to complain to their authorities. They should have the possibility to also join a group action, a collective redress action under the AI Act. They should have the possibility as well to be compensated. So I'll start with this, but I'll be happy to develop on these points and others over the next few minutes. Thank you very much.
Thank you, Federico. I think there's a lot in there that we will indeed want to come back to. You mentioned future-proofing, and I think it's clear that the desire to future-proof leads to a very wide definition of AI systems, which is basically all software that anybody addresses, which leads to a desire to not over-regulate, and therefore a division between high risk, whether the high risk and other, and whether that's struck the right balance or not is another question. Cornelia, I know this is an area which you and Microsoft, of course, have views about, and probably more expertise than the vast majority of people in the room, certainly than myself. Do you want to sort of wrap up this for the first round robin, and then we can dive deeper?
If I may. Is this on?
Seems to work, yeah.
Okay, perfect. Thank you. First of all, I'm grateful to be here. I'll probably dive into 3 issues in this first round and hope to be very quick. The first is to talk a little bit about what Microsoft internally has done so far, because our position on the AI Act is really driven by our own experience in setting up a responsible governance system. I will then dive into sort of the topic of this panel, and I think we can build on the previous panel as well a little bit, because a couple of these issues have already been touched upon in the previous panel. And what role we believe we play in this, and then eventually give one example where you see how complex this allocation of responsibilities is, and where the shortcomings potentially might lie in the AI Act. And maybe just to say that you might think that the civil society's position will be very apart from the position of the industry, but I think we came to very similar conclusions, in particular when it comes to the role of the user in the overall life cycle of a responsible AI system. So starting with where we're coming from, so Microsoft, as many other companies and as many international organizations, including the European Commission, have set up these high-level principles. Whether you call them ethical principles or responsible principles, I think they were a starting point of the discussion far and foremost. But what we have been doing since then, that is back in 2016, we have been starting to set up the governance that allows us to operationalize these principles, so reliability, safety, transparency, accountability, fairness, and inclusion. What does this entail? First of all, it entails that our leadership is all in and really leans towards the processes that we require. We have then set up, starting with our Ether committee, which is an engineering Microsoft research committee that is really diving into the essence of this. So the research, a couple of names for those students that are into the topic, like fairness and accountability. Jen Bullman or Hannah Wallach are leading Microsoft researchers that look into, for example, how to build fair systems, what it entails, or accountability. There are many more, and they're all really great researchers. And of course, they do this in interaction with externals as well. We have the Office of Responsible AI, and this is the critical entity now, has grown enormously in human resources. They have developed a standard that is now starting to be deployed within our engineering groups and sales organizations. And just to give you an example, so basically, what we realized in the iteration of this standard, standard not in the sense of harmonized standards, but more like an internal policy that is a requirement for our engineering groups and has to be complied with. We had a first standard draft in 2018, around 2018-19. I'm getting confused with the years. And the feedback from our engineering groups was basically they need more guidance. They need to understand what we want to achieve. And so we have, for each principles, we have sort of developed a goal. Like if you, for example, want to be accountable, you need to have data documentation. So each principle has a set of goals that need to be, that gives the sort of the context, and then the requirements that follows. So for example, for transparency, one of the goals is that you communicate clearly with the stakeholders that are impacted, be it the user or others. And that means that you need to identify the stakeholders, that you need to share information with the customer, and you need to review and update documentation at least annually, and when an updated condition is met. So it's sort of a real standard that engineering groups can follow, and we have this for all the principles. It's really interesting when you come sort of to fairness. By the way, a piece that we don't really see is met in the requirements listed in the AI Act. So here, what you need to think about, son is calling, the sort of what you want to achieve is, for example, the same level of service for different demographic groups. So then you would think about, you need to identify the demographic groups which they are applied, etc. So it becomes very procedural in order to do this. So this is what we have been doing internally, and this is sort of the experience from that exercise, which is ongoing, and quite an enormous amount of work with many people. That is where we have looked at the technical requirements that have been listed. The second point that I wanted to make is the allocation of the responsibilities. So we have been looking at this, and I personally was very surprised to see all the requirements imposed on the provider. In fact, I would have thought that the Commission would come more from like a GDPR perspective, where you have the controller who defines the intended use, and you would then, follow the processor, or the provider would then follow basically the obligations that are imposed on the user, and this would have potentially avoided a lot of the issues that now the civil society is concerned about. So you would contractually basically impose down the value chain those obligations that the user itself cannot meet, but is required to implement, and that can be done through contractual obligations and distribution across the value chain. This is at least something that I thought would come, so I was quite surprised to see that the Commission has taken a very different approach. And now here's the situation a little bit. So we were like, okay, obviously we immediately felt like we are the provider, except then you read recital 60, and I just read it because I'm sure not everybody knows by heart all the recitals. I hope not. I would be very afraid. So it says, in the light of the complexity of the artificial intelligence value chain, relevant third parties, notably the ones involved in the sale and the supply of software tools and components, pre-trained models and data, or providers of network services, should cooperate as appropriate with providers and users to enable their compliance with obligations under the regulation, So, in fact, in many occasions, we're probably a component provider with pre-trained models and provide those components to customers that then build the AI system. So it would be our customers that would fall under the AI Act requirements. But at the same time, and this brings me to my last point, even that, and of course then you can think is exactly what I said before. You could imagine that the provider would then contractually oblige us to submit the information they need to be able to fulfill their requirements, which, by the way, then they have to provide to the user, for example, in the context of a data protection impact assessment that the provider still has to do, because, of course, these are complementary obligations. So that's one of the parts. At the same time, you will see that how the model is used in a specific circumstance will enormously impact the quality of the model itself. So. One of our research groups in Cambridge, that is in Cambridge in the UK, is specialized on health. They do some projects that involve basically mental health protection, so that workers in the health sector can better serve their patients that have mental issues, and they would develop basically models in order to define the improvement of the conditions in order to identify the right medication. But in order to do so, it depends when the health worker would be confronted with the systems. So the timing of when you would give these models to the health worker have an indication on the accuracy of the system. So this is just a small example to show that the specific conditions in which systems are used are absolutely relevant, in particular in standalone AI systems that are used in service contexts. And Annex 3 are basically all services and not products, where the user will use these systems to augment its own decisions. But there is a lot that the user needs to do in order to ensure that it's a responsible deployment. And I think there is a little bit of issues, and maybe we run a risk that with all the way that it is drafted, we will tick boxes with standards, but the use cases still remain largely unregulated, and I'm not convinced that existing laws are entirely capable of addressing the specific issues that occur with machine learning and AI systems. And there is already starting research in this space that also showcases that. And now I spoke probably way too long. Sorry.
No, not at all. You raise a lot of issues we'll come back to, and that also that tie into some of the other comments that have been made. To go right back to the beginning, if you don't mind, Georg, I was struck by one of your statements to the effect that the AI regulation or act may prevent the full benefit of AI, the full exploitation of AI. And I was wondering why that should be the case. There are certain use cases which are prohibited, and Federico has argued that there should be more of them. I take it you're not arguing that people should be allowed to use AI for those purposes. Otherwise, you could be arguing that the regulation itself and the fear of liability or responsibility could lead to lower exploitation. But tell us what you meant by that.
Not at all. But first, I would like to make a remark which came up to my mind after listening to the panelists. The question is, what is wrong with the AI Act? It's just a title. It's a very arrogant title which assumes to be the one solution for everything. If it was called the AI System Safety Act, it wouldn't have been that sexy. It wouldn't have gained that attraction, but it would have described what it really is. As I said in my first slide, it's not more, not less than product safety law for AI systems. And that makes sense. It makes sense to do it, but we shouldn't expect too much from it, from that piece of legislation. It's just one brick in the wall, just one piece in the whole building. And I think their over-expectations just attracted by this super stupid title AI Act, which goes far beyond the content of it. But if we come back to that point, which is super interesting, why is it discouraging? Why makes it impossible to exploit the full potential if we apply this act as it stands? Just because, first of all, we bind we're making the business. The user, Federico, is a business user. It's companies who are creating something by using AI systems, but they fall back into a consumer-like position since they can use it according to the use of instruction, and that's it. And if they change the purpose, which means they use it for something different than it was indicated in the use of in the instructions, they get provider and they get fined, they get liable and anything. So they cannot derive from the user instructions at all. Otherwise, they have a tremendously risk of being liable and being fined by the supervisory authority. They will not do so. Second, the providers will be usually a company using a Microsoft system or other big company's system, and they will modify it for the current user's purposes. Once they do so, they modify the system, they get providers. They are addressees of all the duties, and Microsoft is out. So that's not attractive for an SME to create any software based on some general parts or components and create it for their respective customers. So that's a big discouragement for anyone who has a small market but not the budget that Microsoft has. You were listening for 10 minutes what Microsoft has done in the past to create an efficient risk management system for their software. How would you do? You can't. And how is it possible to be a provider responsible and as SME, since you want to enter the market and you confronted with such a big amount of duties? That's what I mean.
Well, Frank, you're right. I couldn't, and I probably shouldn't, because if I wrote an AI system and put it out there in the market, that would be a very dangerous thing to do. But you're suggesting, Georg, that the rules are too prescriptive, and I have to say I'm not entirely convinced, because whether you are overly constrained by the instructions that the developer provides you depends on how prescriptive those are. And if the developer has issued a set of instructions which are appropriate, then if I do something different, then there may be a problem there, and maybe I should go back to the developer and ask. But Betty, I'd like to just let you jump in here, because you've thought a lot about how AI systems, in particular, given their decision-making capability, which is different than the hammer, which if I hit my thumb with a hammer, which has been known to happen, there's probably not really an issue of legal responsibility, but AI systems have a sort of a quasi-autonomous characteristic. How should that be taken into account in all of this discussion?
Well, the autonomy of artificial intelligence is precisely the element why we were thinking about regulating artificial intelligence in the first place, especially with regard to liability, because the original discussions were, okay, of a software engineer, if I write an AI system that is making decisions to a certain degree autonomously, and then it causes damage, I don't want to be liable. And on the other hand, we had a consumer who was saying, okay, I will get a system that will decide whatever it wants to a certain degree. It might cause me a damage, and then I don't want to bear the cost. So actually, the autonomy is the reason why we are searching the balance between rights and obligations. Now, with AI, it's a very specific situation, because, and I will now focus on machine learning, because it's where the algorithms are derived directly from the data, and that is where it gets interesting, because there the level of control of software engineers is highly reduced, and actually machine learning and data-based algorithms kind of show us that we all need to be aware what kind of responsibility we are bearing in the society. And now, forgive me for this bigger picture, but we are all producing the data, we are all producing the big data, and all the algorithms that are derived from them are based on our decision making. So the autonomy of those systems is kind of reflection of what is happening in the society, and we might want to somehow steer how we really make the system decide, because our society does approve certain kinds of behavior and certain trends in our development, and then disapproves of other trends that are harmful to society. So we really need to think of AI in the terms that whatever is in the algorithms and in the autonomous decision making is reflecting and magnifying what is happening with us. Therefore, for instance, I personally agree with principles such as data governance requirements, where we are making sure that the data that are selected for training the algorithms and then actually enabling the autonomous decision making are correct and diverse and quality and justified. So Does that reply to your question?
Yes, although it raises a lot of other questions, because the Data Act, for example, to go a little bit off agenda, includes a whole new set of obligations and rights relating to the data that we generate, which feed into the AI Act and other GDPR and other measures. And it's a question or mystery to me how they will relate to one another. So if I have rights in the data that a quote-unquote product for purposes of the Data Act generates, and those data are being used in an AI system, and the developer or the user, professional user of the AI system identifies a defect in the way the data are coded or categorized. Meanwhile, those data have been transferred pursuant to the Data Act to another entity, which is also using them in an AI system. How do those legal measures relate to one another? Maybe that's not entirely fair because we're supposed to be talking about the AI Act, but if anybody has views on how these measures relate to one another, I'd be very interested in that. Federico, you're looking very curious here.
Thank you. I'm not an expert on data protection, and I'm not going to put my colleague on the spot here, but yeah. If I may, I would like to come back to a couple of points that were mentioned. Namely, I find very interesting what was referred regarding the title. And the problem with the title is that the Commission wanted to present the AI Act as a horizontal piece of legislation that would regulate AI horizontally. What we're having here is a mismatch between the title and the actual content. So since we cannot change the title now, we have to address the content. but it's an interesting thought, though. On the allocations of responsibilities as well between the users and the developers, sorry. Indeed, our view is you really only get half of the job done if you put certain obligations on the developers, but not so many on the deployers. And there we agree that we need to create some obligations on the developer, on the deployers, sorry. So in our view, there should be an impact assessment that should be carried out by the deployer. That should include a fundamental rights impact assessment as well. This would come after the impact assessment that should be carried out by the developer. So for us, it's not so much about deleting the obligations that are currently applicable to the developer, but rather adding new obligations to the deployer. Yeah.
When you're talking to Americans, you often hear the comment that Americans invent things and Chinese make them and Europeans regulate them. And I have to say, when you say we have to add more regulations and more impact assessments and so forth, that does kind of resonate. But Cornelia, you mentioned the possibility or the fact that there isn't an allocation down the value chain in the Act. But why can't that be done contractually? Isn't that part of the normal structure of a product liability regime, where you introduce some level of more or less strict liability, and then you leave it to the insurance sector and contracting parties to allocate responsibility? Is that not available?
But that would be if you start from the user and then go down to sorry. So that would be the other way around. I think that would make sense when you start from the user. So you have the and of course the impacted citizens, so in their role as a consumer or patient or customer or citizen vis-a-vis the public sectors that are included in Annex 3. For them, and this goes a little bit to the requests of the civil society, they would want the transparency happening where these are deployed, and then of course let's say justice ministry that deploys a certain system would per public procurement require that a AI system provider has to fulfill certain obligations, and you can basically list 8 to 15, and they can push this into a public procurement document and would this would be the same effect, but this is basically going to my first point. But if I may stick to this for a second, because we don't have this, and the Commission, at least in our conversation, this is how I understood it, they focused on the provider because that is where the expertise sits. But of course, the expertise sits only where we control this. I think the expertise on the deployment side has to sit with the deployer, whether this is a public organization or not. And it's, by the way, interesting to also compare this with the starting negotiations on the Convention on AI by the Council of Europe, and Microsoft as a digital partner to the Council of Europe has the opportunity to be an observer of those conversations. They have taken a very different, they have taken a different approach, and so far, Frederica, what you said is like incentivizing a governance system broadly, and then having very specific obligations for, in particular, the public sector, so the governments and the usage of AI systems for the governments. And they are not, and I think that's more a technicality of the functioning of the European Treaty, that the Commission is sort of bound by using legal basis that ensures the internal market, and that is always a little bit of an issue. So, but if I may go back just to this allocation, another challenge, of course, so I mentioned recital 60, but equally we need to think about Article 24, so obligations of a product manufacturer, which is the user of the AI that is embedded in the product. Under Article 14, there's a shift that the product manufacturer will then be treated as the provider. So they used the product legislation framework, reversed it and reversed it back in the obligations. And then we have Article 28, and I still haven't really figured it out, but in Article 8, there is a reversal of obligations as well. For example, when the user places the high system under their name and trademark on the market, or when they modify the intended purpose, this goes back to Professor Borges' point, or when they make substantial modification to a high-risk AI system. And again, here, the question is, what is a substantial modification? Because I mentioned already where, in our case, Microsoft develops components that our customers use to build AI systems. But we often have this pre-trained model or an AI system that our customers then use to in the specific situation. In order for them to work, they fine-tune the system with their own data, and then the question is that already making substantial modifications to a high-risk system or not? I'm not entirely sure, but this could again switch the responsibilities. And one question then is, so the ground rule of the AI Act is that the provider has the burden of the requirements, but there might be many cases where there is an actual shift, and so you have a little bit of an legal uncertainty when who will have to carry these obligations. And so besides the point that civil society makes in what they need in terms of the deployer, I think it would have been preferable to have a system where the obligations are clear from the start and remain clear whatever the stakeholders in the value chain do. And that would have been if we allocate the obligations according to the environment that each stakeholder can control, and then the rest will have to be done with contractual obligations. So, a deployer of a developer of an AI system can control the deployment phase. This is what we do with our own standard in the deployment. So thinking about it, starting with an impact assessment, making sure it's fit for purpose, it's describing the intended use, find the necessary mitigation procedures, etc., etc. Once it's in the deployment phase by a customer of ours, they need to equally think about their environment in order to deploy it responsibly.
That all makes a lot of sense, but given the difference, the difficulties of drawing those lines and the need to future-proof, would your suggestion be that it should be done, or would even be possible, to draw clearer lines within the regulation, or would, from a liability perspective, would you prefer, probably not a corporate perspective, but from a legal framework perspective, would you impose joint and several liability for all responsibilities on everybody in the chain, and then leave the insurance sector and contracts to sort it out based on a fault basis?
So if we stick to responsibility and leave the liability a little bit aside, let's wait for what the Commission comes up with in October. I think that in certain situations, maybe some contractual agreement needs to be done in order to make sure it is clear. And by the way, the Liebe IMCO committee has already at least hinted into this direction, if I understood it correctly, in a specific situation where the data is actually coming from the user while the model is built by the provider. In those cases, they say that there should be an agreement, a contractual agreement. So I think this would be a good possibility indeed.
Federico, Cornelia, you alluded to the product liability measure that's expected in the fall. We also have a brand new collective redress directive, which was argued about for many, many years. Why do you think, Federico, that these issues should be addressed more fully and more aggressively, so to speak, in the AI Act, as opposed to being covered by these other purpose-specific measures?
Thank you for the question. Just coming back, if I may, a few seconds to the allocation of responsibilities. So here we're sort of talking about the AI system that we can call normal. I think it becomes even more complicated if we start talking about general purpose AI systems and about the allocation of responsibilities between the developer and the user on general purpose AI. The French presidency issued a compromise proposal exactly on this point: what should be the different allocation of responsibilities between the developers and the users of general purpose AI. And we think, of course, there's always room for improvement, but it's a very interesting first step. Regarding the question on collective redress, the idea here, and we were really, I think it was when I read the AI Act draft proposal, it was the first thing that came into my mind was the Commission has not introduced a collective redress proposal. So they have done it in the DSA. It was included in the proposal. The DMA, which was also adopted recently, it was not included in the proposal, but was then added in the negotiation procedure. So why should it be in the AI Act? First of all, to ensure consistency with all the measures that the laws that are currently being adopted at the EU level, but for other reasons, to maximize deterrence from the part of the developers and the deployers on, so that they know that if they do not do their jobs correctly, consumers can group along and start collective redress action. And we know from many research, I think collective redress was one of the files in which my colleagues worked for the longest, perhaps with roaming. They've been working on this for 20 years. So we're very, very, very happy that it was finally adopted. And there is research showing that consumers feel more confident and will have actually the courage to take action against a big company if they are supported and if they are following other persons. So, and the way of doing this is actually rather simple. You simply add an amendment to the AI Act, which will, very technically and legally speaking, mentioning that the annex of the Representative Actions Directive, which is the Collective Redress Directive, needs to be amended to include the AI Act. So it is fairly simple, let's put it like that.
You mentioned the French presidency proposal, and Betty, you mentioned earlier the position of the Czech government, and I wondered if any of you are able to comment on the likely timetable and key issues for this law. The French presidency has been amazingly successful in a number of major matters, such as the DSA and the DMA. I think everybody understands that the AI Act is not moving so quickly. What's the prognosis for the Czech presidency, to the extent you can comment?
I really wish I could give you some answer. The thing is that now with the war at Ukraine, there are maybe the priorities shifted a little bit, because that's one of the main issues that the Czech presidency is also going to focus on. With regard to AI Act, there are some discussions. I don't see into the internal government negotiations and debates, but I believe, or it has been stated that artificial intelligence is one of the priorities. We would, of course, love to push the legislation to be in the form that could be approved, but of course that is only my personal opinion from what I see in the public discourse, and I unfortunately cannot give you any definite answers. There will be attempts, but as to the success, we shall see.
It's not an easy file. We have a few more minutes before I'd like to open up the discussion to questions and comments from the floor. Are there any questions or comments that any of you have for one another before we open up the discussion more broadly?
I have eventually one point, and that goes to the measurement of the requirements. It's not entirely related to the allocation of responsibilities, but I think it's super important in the context of whether the AI Act is going to be fit for purpose and whether we are going to achieve what I think the reason is for having the AI Act in the first place, and it's not only, and this is sort of like, it's not only safety. The AI Act absolutely wants to ensure that fundamental rights, broader than only safety, are protected. But the issue that is missing is how do we ensure that these technical requirements actually do this? So one of the feedbacks when we last year sort of responded to the Commission consultation and had this internal discussions with all these super smart data scientists and researchers and social scientists internally, and they were looking at these technical requirements, and I mean, most of the people, of course, know this accuracy as it was sort of framed in the original Commission text. Everybody agreed, well, this doesn't work because there is no such thing as like a 100% accuracy of data. But more generally, and I think it's addressed in almost all texts and proposals that we have seen, but more generally is this, how do you actually measure certain of these requirements? And that's in itself a research area that is evolving very quickly. So what we internally do, and this goes a little bit to your point again, we are a big company heavily invested in responsible AI, but as we have started to impose these obligations on our engineering groups and our research entities, sort of define how you can actually move to transparency, intelligibility, fairness, etc. We are, as a tech company, now developing the tools that make that actually possible, so that you have the ability to think about how, see whether certain fairness metrics are met in the system. So that is for our customers to be able to play around. What that also means is that you have to understand that these technical requirements, they interact with each other. So you might have a context where accuracy is more important than in another. Think about facial recognition technology, where accuracy is very important, but then you might need not like 90% accuracy in another system where, for example, fairness is becoming more important. For example, when you allocate eligibility for loans as a bank or so. So that all of that is sort of super complex and can be helped with tools, but it doesn't show really in the AI Act, and I'm not sure whether through standards that will necessarily improve. Sorry, that was lengthy.
Just one remark, Federico. I have a long wish list to the European legislator regarding AI systems. For instance, we need the right to know more about the decisions made by systems, but it's not the producer who can anticipate all the decision making. We need right to access to data for systems for testing independently. The AI is just providing testing by the provider, but I'm the one who is confronted with the decision. I want to test it, or your organization wants to test it. Consumer organizations want to test AI systems, they need access to it. That is another field. And that I have a long wish list of such kind regarding the risk associated with the use of AI systems, way beyond traditional product safety. No question about it. So if you really want to open the box and now we have the title, you want the content, there's a lot to add actually. But let's limit to what it really is, and then we need future legislation more specific to some of the other issues related to AI. And there are some, definitely.
I mean, I agree with you, so yeah, I just wanted to make a point on the fact that we released very quickly a survey a couple of years ago, and this is about the fact that AI Act might hinder innovation and so forth. And we released a survey a couple of years ago that basically showed that consumers have two big fears regarding AI. And first, they fear that it will basically lead to more abuse of personal data. It will lead to more abuse of their personal autonomy. And secondly, they fear that authorities will not be able to exert control over this technology. So we really have to look at the perspective of the AI Act that as a tool that will also boost consumer trust and will enable the technology at the end of the day to develop. We are not against the AI, not at all. We want this technology to roll out and to develop, but within certain rules, very specific, AI related, that hopefully we can all agree at the end of the process.
Betty, do you want to close that part of the discussion and we'll open?
I actually wanted to react on one of your remarks on my one of the interventions I had on where will it end with the distribution of obligations and with regard to data. I was thinking about it a bit, and actually what my final remark in this is that what I am missing within the last few couple of months and years, we have had a number of important pieces of legislation proposed, such as DSA, Data Governance Act, the Data Service Act, Data Market Act, now the AI Act and Data Act. And what I am missing here is that actually if somebody would sit and take all of those pieces of legislation together and kind of assess the impact of the compound effect of all the legislation on the business environment and on the rights of users and all of the subjects. Because I think that maybe if we then do some case analysis, make some example scenarios and assess them, we might find out that maybe in some legislation there is something extra that we don't need that is covered in another legislation, and maybe we are missing something. So maybe this could be the next step in progressing in the future legislation.
That sounds like a thesis for your next book. We have questions. I see one person already standing, and that may indicate a question. Do we have microphones in the...
I think he's standing in front
Yeah,
of
great.
Hi, Michael Veal, UCL. On Michael Veal, UCL. On the issue of adding complaint rights, how do you add a complaint right to a piece of legislation that confers no rights on individuals? What exactly would you be complaining about in a collective redress? And how can you extend product safety in that way? And similarly for enforcement, how can a market surveillance authority, which is maybe supposed to be independent from businesses, enforce against most high-risk AI systems when most of these are going to be public-private partnerships, so it will be enforcing against another department of the government, when mostly market surveillance authorities are government departments, not like data protection authorities?
Thanks a lot, Michael, for the excellent question. So the idea as well is, as I mentioned in one of my first points, would be that we would add a new provision that would come up with certain principles that would be applicable to all AI systems. And some of those principles would be transformed into specific rights to consumers. So the principle of fairness would somehow allocate a specific right to consumers that the AI system that they are using would be fair. The same for transparency, the same for accountability. And on top of that, we would add, for example, the right to an explanation. As for the role of authorities, that's a great question. We've seen the example that we can have, or the bad example we can have with authorities under the GDPR. There's clearly a need to cover all those problems under the AI Act. We're still assessing how to interpret the proposals made by the co-rapporteurs in IMCO and LIBE regarding the boosting quite significantly the role of the Commission into the enforcement system and replacing national authorities if needed be. It looks like a good idea, but again, we're still assessing that, and there were quite a few ideas. For example, they say at some point, or the draft report says at some point that the Commission can act if a market surveillance authority has not taken a decision, but you do not define what decision is. So what does it mean, a decision? Start an investigation, conclude an investigation. So those are the type of issues that we are very, very thoroughly assessing, and yeah. Thanks for the question.
I just have an opinion. I mean, this is obviously something that it goes a little bit back to the rule of law and how the governance is structured, and sort of the division of competences as well. And as I mentioned, this is why I'm actually quite, as a citizen at least, I'm quite fond of the approach that the Council of Europe is taking, where there is a very clear differentiation between governments and the role that this convention will have to protect citizen rights vis-a-vis the governments. And then separately have the obligations for providers. And of course, this doesn't come through at all in the AI Act. And it always comes back to the choice that the Commission has taken in using the new legislative framework as the grounding for an AI Act that goes way beyond, at least in its ambition, beyond safety regulation. Absolutely. I mean, we're coming always back to that point.
5 minutes, we are warned. Anyone else have questions or comments?
Hi, Ben Aderson from RAID, which is a conference about the regulation of AI, internet and data. It's a question about the speed of the development of AI, really, and what that means. So it's developing very quickly, and that's only going to do so more and more quickly, with the rise of quantum computing and the sort of environments that AI is going to be operating in as well, the metaverse, virtual environments, that sort of thing. question is, are legislators able to keep up, or do they need to be in closer contact with developers and industry to understand the capabilities of technology and the environments that it operates in order to future-proof legislation? Because Microsoft has obviously been looking at this for much longer than the European Commission, for example. Hope that made sense.
So generally, I think the Commission, the overall process from the high-level group on AI towards the proposal of the AI Act was quite open in the consultation, except for, I think, the last couple of months where the Commission sort of closed the shop and worked this out. Maybe it would have been good to have some more input at this stage when they came up with the proposal, because I think there is a broader consensus that the approach is not quite fit for the purpose.
Osbeta was one of the members of the expert group, I think, that was working on trying to be a bridge.
Yes, it was together with Professor Borgs. It was the expert group of Newton Technologies and Liability, and if I remember correctly, we did have experts from different fields who were talking to us on what are the problems, such as in the financial sector or in autonomous vehicles. And I believe that you cannot make legislation that is based on just theoretical considerations. You need to talk to industry. For instance, in the Czech Republic, there is a platform for AI that gathers representatives of the industry, and whenever there is some consultation on AI Act or on a new legislation related to AI or other business-related issues, they are consulted. So the group of people from the practice really sits and gives their opinion on what could be improved or not. So the debate is there, and I appreciate it very much.
I think we have time for one more question.
Can I add? Sorry, I think it's very interesting what the co-rapporteurs have done in the draft report by including on several different stages of the AI Act, the inclusion of multi-stakeholder participation, industry, civil society, academics, real experts on the topic. And this, I think, needs to be praised. And also one concern that we have, which is also related with market surveillance authorities, there's clearly a lack of expertise on this technology. So it will be a very, very important challenge for market surveillance authorities to apply this. And we need to make sure that the system we create, also linking to Michael's question, is very well oiled to make sure that those that infringe are quite quickly addressed and penalized. Yeah.
One final question or comment?
I have a question. My name is Oludare, Tilburg University. My question is really with regards to the right to explainability and the concept, the black box concept. How does the corporation go about handling this? And the proposed act doesn't really seem to address that, because from my understanding is even developers too can't explain it to the consumer what's really going on in the algorithm. So I don't know if anyone has anything to that. That's just my question.
Well, the black box effect is addressed by the testing obligation. So as a very important part of the risk management testing, and that's the way to open the black box as to its results. And that plays an important role in the AI Act concept. So I think I still wish, I come back to what I said earlier, I still wish that independent testing will be available regarding AI systems which are used to evaluate people. So that I agree, but in principle it is addressed by testing, and in one of our projects, or in several of our projects at my institute, we were dealing with the question how to open the black box, and apart from explainable AI, which is still in its infancy, I think testing is just an approach which should be taken, and we cannot reproach the Commission there, since testing plays an important role in the concept.
Thank you.
I think we are out of time. Thank you very much to everybody and to the audience for your questions and participation.